Welcome. Thank you so much for joining me today. And I'm excited to have you here. We're going to talk about Delphi, just a little bit of a review because as we're streaming live, they should be in their hearing right now, which, as we know, Judge Gull is not allowing any cameras or anything in. So it'll probably be by the end of my show before we actually get any feedback from anybody that has been in attendance of the hearing. So because they'll go at least an hour and a half, 2 hours before they take a morning break. And then maybe somebody might run out to give some kind of information about what's happened so far. But if I recall the last hearing, if anybody left, they would have lost their seats. So like Bob Motta of Defense Diaries podcast decided to stay in his seat. So we didn't hear anything from him until the hearing was over, or at least broke for lunch. Okay. What is today's hearing about? It's about two things. First is let me get you the exact name, motion for pretrial hearing. I believe that's the one because the defense has asked for many hearings. A Frank's hearing, motion to suppress hearing. I don't know that she's actually going to do anything about those. So motion for a pretrial hearing, and then also the state's motion in limine. So we'll go over those two things and see exactly like what's going on. So let me see if I can share. Wait. Can I upload slides? PowerPoint. Delphi. Let's see if we can open this. Looks like it's opening. Hey, Chalet's in the house. Good morning. I'm not sure if Mumsy's going to be here today. She's got something she's busy with, and so maybe not. But I hope Andy and Lemoyne and True Crime Cult and everybody comes in. Okay, so I'm going to add this to the stage. All right, let's see if I can I zoom? I'm going to go full screen. I don't think I can zoom on this when it's this way. Okay, so I'll just have to tell you what it's about. Let me get it where I can see it bigger. Oh, no. Escape. I don't want that. That's better for me. Okay, I can see it. So on April 30th, the defense, through Richard Allen, through his lawyers, filed a motion for pre-trial hearing. You'll just have to trust me that that's what I'm showing you on the screen. I'm sure you can't read it because it's so small. So they respectfully request at this court, I think that's supposed to be that. So respectfully request that this court conduct a pretrial hearing to address scheduling and other procedural matters. Well, that can cover a lot. Involving the jury trial in this case. In support of said motion, defendant Allen states as following. 1, on March 6, 2024, Richard Allen filed his motion for early trial. The motion did not make any references to the anticipated length of said trial. The motion satisfied the requirements of Criminal Rule 4B1. All right. Number 2, on March 7th, 2024, the court issued an order granting said request. and set the matter for jury trial between the dates of May 13th and May 31st, 2024. The order was uploaded to the chronological case summary on March 11th, 2024. So number 3, between March 7th and April 25th, there were no communications from the court to the parties as to any matters associated with the procedural aspects of the jury. Okay, because one of the things they attach in here is the email from Judge Gohl saying, well, nobody said anything to me, so I just picked 2 weeks. Nobody said how many witnesses they were going to have, nothing. So 2 weeks, that's it, right? That's what so they're responding to her email by filing this motion for a hearing. Okay. And we'll get to that because it's an attachment at the end. So on April 25th, 2024, attorney Rosie reached out to court via email to address housekeeping matters. It's in quotes. That's why I did that. Said email addressed issues including, but not limited to, the logistics associated with defendant Allen's attendance at trial and the need for a working space in or around the courthouse to store defendant's trial materials. The email also inquired/requested that the defense be offered up a location in or around the courthouse to meet with defendant in private and in a private and confidential setting. Okay. Reasonable. Number 5, on April 28th, 2024, 3 days later, the court responded via email to various requests and within said response, admonished the parties that the trial schedule contains no flexibility, quote, not more or less, unquote, as the court had not received any objections by the attorneys regarding the court's order of March 7th, 2024. Footnote, see attached partially redacted email from April 28th at 11:15 a.m., which contains redacted information and communications above and beyond that which is relevant to this filing. So some of the information has been redacted. Oh, coffee, that sounds so good. I've just got like regular water. Okay, next. Number 6. The court further acknowledged that the court was, quote, unaware of how many witnesses the prosecution intends to call, nor on how long their case will take to present, unquote, and reaffirmed the schedule reference above, that it's only going to be 2 weeks. The court also referenced that the defense claimed that it would take, quote, a couple of weeks to present its case, presumably referring to a phone conversation between the parties back in September or October of 2023, when attorney Rosie confirmed with the court that the defense intended to try the case on the previously scheduled January of 2024 setting. Finally, the court acknowledged that the court was unaware of, quote, what exactly the defense intends to present, unquote, to which the defense would respond, quote, exculpatory evidence tending to show that Richard Allen is not guilty of the crimes for which he has been charged, unquote. Just doing their job. Either way, the court's unawareness of the nature of the defense's presentation and the state's presentation would naturally be the catalyst for pre-trial discussions regarding scheduling and logistics. So right here, they're saying in her email, she says, nobody's talked to me. I have no clue what you guys are planning, so I'm giving you 2 weeks. Well, if she said, I have no clue what you're doing, then it's like set a hearing, set a pre-trial hearing where everybody can say, give her the information that she needs to determine how long it should be. Number 7, over the past several weeks, the parties have filed notices reflecting their exchanges of witness and exhibit list. The state's original witness list contained 118 witnesses and approximately 93 exhibits. The defense's original list contained approximately 71 specifically referenced witnesses, not including several others that were referenced more generally as having been associated with various motions and memorandums filed by the defense. Supplemental lists have been filed by both parties, further expanding the volume and witnesses and exhibits. While there are some duplicated witnesses, there are many that are not duplicated. In fairness, the court is unaware of the details regarding these lists, as the parties have filed only notices with the court, memorializing the exchange of such lists with each other. This approach also assisted in maintaining some privacy with regard to those individuals who were going to testify at the trial in this cause. Number 8. What was that? 8. In addition to the raw amount of witnesses and exhibits that have been noticed up by each party, there exists logistical challenges knowing defendant Allen will be transported to and from the trial significant distances each and every day, possibly as much as an hour and a half each way. The court confirmed this in its email to the parties on April 29th, 2023. In addition, defendant Allen's attorneys will be traveling from communities outside of Delphi. The court's instructions seem to suggest that the jurors will also be located a distance away from Delphi. It seems natural that there will be additional challenges that cause delays in the trial, thereby consuming even more of the time allotted for the presentation of evidence. I would like to mention at this moment that Richard Allen has been moved, apparently, to the county jail. And so he's got a new mugshot. May 6th, so yesterday, I believe. I'm just checking here. I can share, let me share the screen with you guys. Oh, that's not what I want. I want this one. Okay, so here's this new mugshot. Let me check your, yep. For what it's worth. His eyes look kind of psycho. And so I'm just want to see if they have, people are talking about the weight and what he's looking like. PCA. Okay. Nowhere here is it mentioning that the point that he has been moved. So I do think it's almost a prosecution tactic to get him looking as close to the bridge guy as possible. So they've been fattening him up and everything. So take that for what that's worth. And I think that this is from Carroll County Jail. See, I don't have anything to tell me exactly. I just have that. The food, no food is very fattening in jail. Everybody gets fat there mostly. Yeah. I think they were just starving him and not giving him much before. So anyway, let me switch over to this one. All right. Oh, we have gone, I think, 3 pages in. Yeah, we're on the 3rd page. The food is full of sodium and fat, I'm sure is what you're going to say. Lots of processed foods. Okay, so at least he has been moved to the county jail, from what I hear. There's nothing else to do but eat. Yeah, Chalet. for sure. Number 9, it is also noteworthy that the court has denied summarily almost every pretrial challenge by the defense throughout this case. The net effect of these summary denials is that the defense will be required to introduce evidence by way of offers to prove, which I think are called proffers also, and other procedural techniques in the absence of the jury, but during the course of the trial. This, of course, will cause further delays. Is anybody watching the Karen Reed trial? Because this kind of stuff is happening. I mean, oh my goodness. I have been trying to keep up with that mostly. And if you want to see how the procedure generally works, just follow that. And they do, because they also have the third party defense, the third party defense is what they're calling it, right? That they are presenting specifically someone else that they believe murdered her boyfriend and set her up. Okay, so it's very similar into what Richard Allen's defense theory, defense tactic is, right? And they also are bringing I think they had pretrial hearings where they settled most things, but not everything. So there are times when the jury has to be excused. Okay, the jury's going to take a 5-minute break because there's so much you can do as a sidebar. And then there's other things where you actually have to have court record and arguing the evidence and for the judge to decide whether or not it's going to be admitted. So the jury is asked to take a break, which then slows down the court proceeding. And if it's slowed down, it's lengthened, right? Where is everybody today? I know. So you're following Chad Daybell. I watched a little bit of Chad Daybell, and I don't know. I haven't been watching much of it. And as far as the prison food, you're saying, believe me, I know, not that I've been there. Mumsy, Andy, Queen, Snow. Yeah, exactly. I don't know. Lemoyne, Michael, the crime people. Yeah, like the true crime. It's always a tongue twister. True crime and wine couple. Some stuff is new. Yeah, for sure. Some of this is new. And this is what they're going to be. So I believe that this is the motion for hearing that they're going to be dealing with in court today. And they will be dealing with the motion in limine, which we will go over a little bit because the defense filed a response. I don't think we've gone through that, but we did go through the motion in limine by the prosecution. So there's another, look in my playlist for that, the true crime playlist. All right. So number 9 was that they didn't have pretrial hearings to go over evidence. So then now it's got to be introduced during the trial, which will take time. Number 10, federal courts have a well-documented history of regulating the presentation of evidence to ensure the orderly disposition of both criminal and civil cases. This approach is much less evident in the context of state law. Any existing case law addressing the court's inherent authority to regulate the presentation of evidence typically involves family law matters, not jury trials in criminal cases. For time limits to be reasonable and not arbitrary. Now, this part is in italics, so they're saying this is important. For time limits to be reasonable and not arbitrary, a trial judge needs to review the case and consider the evidence each side intends to proffer. Generally, time limits should be imposed only after the court has made, quote, an informed analysis based on a review of the parties' proposed witness lists and proffered testimony, as well as their estimates of trial time. And then they give a citation. When a court sets limits on presentation of evidence, even before the listing of proposed witnesses, it will be considered, quote, an apparently arbitrary limitation imposed in the interest of conserving judicial resources. Yeah, that kind of sounds like maybe what's happening. She's got other cases on her calendar she's got to deal with. And so she doesn't have time to, she's got to get to those other things. What's she going to do? They deserve a trial too. Those defendants deserve a trial. And she's going to take up all her court calendar for, 2 months. Well, you got to do what you got to do. It landed on your court, so you got to deal with it. 11, the primary goal in filing this motion is to ensure that the court has set aside adequate time for Defendant Allen to present a comprehensive and meaningful defense consistent with his rights under the Sixth Amendment of the United States Constitution. The defense has no control over the manner or methodology of the state's presentation of evidence, including the length of said presentation, which under the current scheduling regimen would consume the entirety of the May 2024 trial setting. They wrote 2023, but of course this is 2024. 12, italics again. When time limits are set, quote, the court must ensure that it allocates trial time even-handedly. Gives a citation. That does not necessarily mean each side must receive the same amount of time, like 1 week for the prosecution, 1 week for the defense. In a complicated case, for example, the, quote, presentation of a competent defense may require more time than the presentation of the plaintiff's case in chief, or in this case, Nick McClellan. Number 13, Defendant Allen seeks equity in the amount of time offered up to present his case. As referenced above, the state could easily exhaust the entirety of the 2.5-week trial setting, excluding jury selection, thereby leaving the defense with very little or no time to present its case. There would also be little time for rebuttal on either side to the extent it is necessary. 14, the court's approach to such a rigid trial schedule infringes upon Defendant Allen's Sixth Amendment rights and underscores the need for the court to conduct a scheduling hearing regarding the trial. By the way, I'm on page 4 now, so let me, oops. There we go. Let me move this to the next slide, just in case someone's actually looking at it. Okay. Okay. Number 15. This case does not present itself to the court as a case of, I think there's supposed to be an as a case of the first impression, at least not from a scheduling standpoint. Your Honor previously presided over the case of State versus Bob Leonard, and it gives the case number, in 2016. The trial consisted of approximately 34 days of testimony with nearly 140 witnesses. The defense sees similarities between the volume of witnesses and therefore believes this case may require a similar amount of time. A full month, at least 4 weeks. To the extent, number 16, to the extent any references were made back in September or October of 2023 regarding the potential length of a trial, those references would have occurred prior to this court disqualifying the defense team. The delay caused by said disqualification has resulted in the creation of additional discovery, which has in turn resulted in the need for additional time to present Defendant Allen's defense. Not to prepare for the defense, because that would be pushing back the trial. They're not saying that, but to present the defense. 17. It is for these reasons that the defense requests a pre-trial hearing to discuss scheduling issues associated with the trial, secure the appropriate amount of trial time for Defendant Allen to present a full and comprehensive defense, and to address any other pre-trial matters that may be necessary to ensure a just and speedy disposition of this cause. So now let's take a look at the judge's email. You can see here on this slide that it's got everybody's email addresses, and then it starts reading, but I'm going to just go ahead and move it to here. So if for some reason you are able to zoom in or something, then I don't have to like move it to the bulk of what's being said, right? So we've got all of the emails. It's from Francis Gall to Rosie, and copies everybody else. We copy Andrew Baldwin. We copy Nick McClelland. We copy the somebody else with the Carroll County prosecutor. And then Jennifer with j1sauger.com and a Diener. But that's not the previous Judge Diener. Remember, there's somebody, a lady with the same name that's working with the prosecution. And her email is carrollcountyprosecutor.com. So, good morning. And this Sunday, the date is Sunday, April 28th, 2024 at 11:15 a.m. Eastern Daylight Time. Good morning. I will answer your questions as follows, and there's some redaction. And then we get to the part that's relevant. And the intent is that the jury selection will take 3 days. Court will be in session in Allen County, beginning at 8:30 a.m. and concluding when we conclude for the day. You have all been provided with the sub-panel lists, broken into morning and afternoon sessions. I will forward to you under separate email the seating charts for courtroom 1 and the strike sheets we will be using for selection. The selected jurors will be sworn in upon selection and ordered to not speak or communicate with anyone about the case and to conduct no research on the case. They will further be ordered to return to the Allen County Courthouse on Thursday morning with their luggage and personal effects, which will be searched by law enforcement officers to ensure they are bringing nothing electronic or illegal. Once that is complete, they will be transported to their hotels by my staff. The order I referenced above contemplates an invitation to the media to meet with me in the Carroll Circuit courtroom Thursday afternoon so that they can take photographs of the empty courtroom and B-roll footage of the courtroom for their stories and broadcasts and to receive their press credentials. Continuing on this final page. This case was set as a speedy trial at the request of the defendant for May 13th to 31st, 2024. That is the length of the trial, not more or less. When the order was issued, she doesn't give the date when it was issued in here. When the order was issued, not one attorney notified the court that the length of the trial was insufficient. Did she actually give an ending date? I mean, I don't think publicly. I think publicly it just listed the start date. So we knew that it would start on the 13th. But maybe she communicated with them on back in the back, you know, such as an email or something that gave the 13th to the 31st. I think publicly we only knew that it was scheduled to begin on the 13th. So Not one attorney notified the court that the length of the trial was insufficient. In fact, it is consistent with the previously scheduled length in January 2024. That's why they mentioned what they did about the previous schedule not applying anymore because there's more discovery. I intend to start court every morning by 9 a.m. and recess for the day around 5 to 6 p.m. Court will be in session on Saturday, perhaps for the entire day if necessary. Court will be in recess on Sunday to allow the jurors and the parties to rest. I have tried death penalty and life without parole cases in this amount of time, all of them with multiple victims. Well, multiple victims is not the same as like defendants. Well, I mean, I suppose you would have more evidence, but not necessarily that much more testimony. Whereas Richard Allen is one perpetrator, but the defense is trying to say that there was more than one perpetrator, not just a different perpetrator, but a group of people. I am unaware how many witnesses the prosecution intends to call, nor on how long their case will take to present. The defense is claiming it will take a, quote, couple of weeks to present its case. This is where they said, no, that's what we said back in September about the January. That does not apply to May. And also when she says, I am unaware how many witnesses, blah, 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 right there is like, well, then why didn't you schedule a hearing? Why do you need to wait for us to request a hearing? Or call them into chambers or whatever. If she was unaware, she didn't just have to sit around twiddling her thumbs. She could have been proactive about it. I am continuing. I am unsure what exactly the defense intends to present. Again, same comment I just made. I am quite familiar with the law regarding third-party perpetrators, and unless the defense can provide a nexus between any alleged third-party perpetrators and the charged crimes, those allegations are unsupported and will be inadmissible. So she's got a prejudice right there already. I think that her and Nick are like this, and and that's where we get to his next. We're going to go over the motion of limine, where he's asking everything that has to do with third-party perpetrators not be admissible, which is like saying that, and remember in the previous show, it was like anything that might confuse the jury. It is like, wait, you mean anything that might cause reasonable doubt? Well, isn't that what a defense is, right? That he wants it thrown out. And I'm looking forward to seeing the response of because I didn't read through the response by the defense. Okay. Please be prepared. Oh, and by the way, the connection, the nexus, the connection. I think there's already been. I mean, what did you not read the Franks hearings? I mean, the Franks motions, right? If she read the Franks motion, she would already see all the connections. And there are more connections with that than there are with Richard Allen. Okay. She finishes up saying, please be prepared to present your cases timely. And she's not talking about this hearing today. She's talking about May 13th for 2 weeks. Please be prepared to present your cases timely. Have your witnesses available quickly and promptly. I look with disfavor on counsel attempting to manipulate the presentation of evidence by timing witnesses poorly. That conduct will not be permitted. The jurors' time is valuable, especially since they are sequestered and away from their homes, families, and jobs. Please respect the sacrifice the jurors are making. Judge Gull. Well, that part I agree with. I'll give credit where credit's due. I agree with that part. Everybody needs to respect the sacrifice the jurors are making. They also need to respect the sacrifice that some witnesses will be making, because not all witnesses, especially expert witnesses, might be someplace else in the country. They might be, I mean, like, what if they call the Purdue professor? You know, they're gonna make him miss classes for the full 2 weeks when it's finals week, right? I mean, aren't most finals being done in May? But he's, you know, if you don't have enough time scheduled, and you don't know when your turn is going to come up next, then that means you got to have everybody there ready. 114 people plus, they have to be there ready for whenever they're going to get called. You can't say, like, okay, here's a 3-day window. We're planning on you being on this day, but let's have you here the day before and the day after, in case things are going a little quicker or if things are taking a little longer. You know, 3, maybe 4 days. But like, this is like the whole time, you know, because you never know when they might get called, right? And quite frankly, according to what she's got so far, the number one, the defense won't have time to call anybody, because it's like in football, when whoever's got the ball, I guess whoever's on offense and winning, they just run out the clock. We know that that's a thing. And you think Nick McClelland's not going to run out the clock? Of course he is. And if she grants his motion in limine, who are they going to call? No, you can't have anybody talk about this, so you can't have anybody talk about that. You can't. Who are they going to call? You don't have anybody to call. She kind of alludes to that in here, then, with her attitude and some of the things she said. You know. So anyway, this email was included as part of their motion. Okay, so we got that done. Let me remove that. Now let's take a look. I'm going to show you the motion in limine. Let's see. The defense motion. No. Must be this one. Can I blow it up? Can I blow it up? Oh, I can't do that. Full screen layout. No. Why can't I, like, zoom it in? There has got to be a friggin' way, and I just don't know how to do it. Okay. How did I do it before? I figured out a way before. Does it have to be open in a Chrome tab? Oh, no. I remember. Remove. You can go away. Okay, I remember. Present. Okay, do that. Share screen. Window. Here we go. Okay. I knew I had a way. It's just been a while since I've done it. So go like that. And then state of Indiana. Okay. So just as a reminder, your cat decided to get sick everywhere. Oh man, that's a bummer. And you can't let it, like, soak in. You gotta get it up right away. Yeah. I hope everything's taken care of now. Hope you were able to listen while you were, taking care of business. TCB, taking care of business. All right. So the motion in limine, this is the one where he goes through, he says, any comments from counsel about the state that constitutes a personal attack on Nick. Any comment which constitutes the personal opinion of defense counsel about any evidence, witness, or outcome or penalty. Any innuendo or inference that's not supported as admissible evidence, which we'll get to in a bit here. So if he strikes everything that's the third-party defense, then any innuendo or inference to that third-party defense would be contemptible. I don't know if that's a word that applies, but I'm throwing it out there. You were gagging. Oh my gosh, Chalet. I believe it. Was it the blind cat? My heart goes out to the blind cat. And I'm so happy that you take care of it. Okay. I love this. Any attempt to indoctrinate the jury. Oh, but that's during Vaudier. By exposing the jury to a substantive issue in the case. And that's actually normal. Okay. You can bring up scenarios. It's kind of like when you want a doctor to give you advice. A friend of yours is a doctor, or a lawyer. So you can't say, oh, I have this pain, right? No, you have to say, hypothetically, if somebody had a pain, right? Kind of like that. It wasn't the blanket. This one just likes to go through his food too fast. Oh, mine do that too. I got 8 of them. So I got to kind of sometimes limit the amount of food. So instead of just putting a thing out with all the food in it that they can nibble at their leisure, I got to give them little bits, maybe 2 or 3 times a day. Because otherwise they eat too much and barf it up. It happens. Can only imagine what fun you have on a daily basis with 9. I know. Well, 8 are in the house. And I haven't seen Mango for a week. But I know there's other people that feed him and stuff like that. So, and there's been this huge heat wave. So I hope he's had water. I've kept a bowl of water outside my front door so that there's always access to water. I don't know. I got to check with the neighbors, the neighbors where he normally hangs out, if they've seen him. He stole it from the other one. Oh my gosh. Do you know what I got to do? Piggy. Well, I'm calling Piggy now. I called him Kitty before, but now I call him Piggy. And sometimes I call him Piggly Wiggly. And he's the one that is pig. And so I will, okay, if it's the dry food, I got lots of bowls. I just put dry food in all the bowls. But if I'm giving him canned food, then I got to take the can and the spoon into the bathroom. And then I give him his in the bathroom and close the door. And then I feed. Everybody else gets along fine. Everybody else sticks to their bowl. They're not, Slinky Dinky, Slinky Dinky Winky. Slinky. That's why his name's Slinky. Her name is Slinky. And so she'll eat really fast, and then she will try to nudge everybody else. But I can keep her, I can just stand in between the bowls and keep her away from nudging somebody else out of their bowl. Whereas Piggly Wiggly, man, he will just muscle right in there and push. It's like a linebacker. Is it a linebacker? Yeah, the linebacker is the one that rushes the quarterback, right, and rushes the receivers and just full speed knocks them down. That's Piggly Wiggly. Maybe I should call him the refrigerator. That's the only linebacker. Everybody else is receivers and quarterbacks. The only linebacker I know is the refrigerator from the Chicago Bears back in the day. Anyway, so let's see. Hypothetical questions that include facts would be in violation of that. Any attempt to introduce evidence of a third-party motive that is not relevant and or the probative value is outweighed by unfair prejudice, confusion of the issues, or has the potential to mislead the jury, right? Again, that's like anything that might introduce reasonable doubt. Let's just say it. That's what you're saying. Anything that goes against our case, you can't say. Like, but him and Judge Gull are like this. So he might get it. And continuing that, this is his list. Odinism, cult or ritualistic killing. How is he? So what? He's going to show crime scene photos to the jury, right? They're going to see the sticks, and they're just going to say that, oh, yeah, Richard Allen's guilty because he just threw the sticks. He just grabbed some sticks and placed them randomly on the body. And then the defense is not going to be able to say anything about runes or call the Purdue professor. Even though it was in their case and in their investigation that they contacted him, they contacted the Purdue professor. It wasn't the jury that found the guy. It was the investigation. The police found the guy. The police got the report. And when the report came back and said, yeah, they're not real runes, but they're definitely an attempt at making runes. And then he lies about it in the PCA and says, no, the Purdue professor said they weren't runes. Outright lie. Hence Frank's hearing. And so if you're not allowed to mention, then you would also not be allowed to call as witness Brad Holder, Patrick Westfall, Johnny Messer, Elvis Fields, Ned Smith, Rod Abrams, Kagan Klein, Jerry Klein, or Ron Logan. Any reference to the investigation conducted by Todd Click? Well, there goes Elvis Fields' spit. Did they ever test for spit? He stole it from the other one. Oh, yeah, I saw that already. The cat, yeah. Okay. The geofencing. Strike anything to do with geofencing. Any reference to any prior bad acts or acts of any witnesses that plan to testify at the trial that is not relevant to what the defendant is on trial for. So basically, we already know that law enforcement has lied, right? Would a prior bad act include lying? Isn't it the job of the defense when the prosecution puts up? I'm watching it right now. I'm watching it in the Karen Reed trial. The prosecution puts up a witness, and then the defense comes and catches them in a lie. Isn't that the normal thing to do? But no. If you reference anything that's wrong, like oh, maybe you wrote in the report bloody clothes when the witness said muddy clothes, but you changed it to bloody, and that was an outright lie because the witness never said that. You can't mention that because that's a prior bad act, right? I mean, God knows how many things they're talking. He's trying to cover up. Nick is trying to cover up by saying it's not admissible. Any reference to any files that were labeled and handed over to the defense as part of discovery. So we know that because it's not just being messy with your labeling, it's trying to hide stuff with your labeling. They were trying to hide exculpatory evidence, right? And but no, but the defense can't mention that. any reference to any PowerPoints provided by the state as executive briefs involving any person or persons that were investigated by law enforcement as part of the 6-year investigation. That would tend to cause confusion of the issues or has the potential to mislead the jury in violation of Rule 401. Yeah, that might bring reasonable doubt. You can't say it, right? So, wherefore, the state of Indiana, by prosecuting attorney Nicholas C. McClellan, respectfully requests this court to grant the following relief. A, order the defendant through his counsel and witnesses to refrain from mentioning, commenting, or making any reference whatsoever, either directly or indirectly, to any of the above matters without first obtaining permission of the court outside the presence and hearing of the jury. Which means if they don't settle all this before the hearing, before the jury trial starts, then every single piece of evidence would be coming in, and having to start, and the jury would have to go out of the room and then come back and everything for every single thing, right? But she is hearing it before. B, to further order said persons to make no reference to the fact that this motion has been filed and granted, and all other relief just and proper in the premises. Which is kind of weird because, I mean, was this supposed to be hidden and not publicly, like where we can, like we all see it? So how can there, or is he talking about in the court in front of the jury? Because he didn't write that on B. Right? He wrote it in A, but he didn't write it in B. He just says, basically, he's like saying like a non-disclosure. Said persons, defense and his counsel, to make no reference to the fact that this motion has been filed and granted, and all other relief just and proper in the premises. So that was the 29th day of April. Now, what I have not gone through, because I just like skimmed over that for you. We didn't read word for word. I hear cat fighting. I wonder if it's like, let me see who the dogs are barking at. I wonder if it's Mango. I don't see anything. But I think the dogs are just barking at the cat fight that I heard. Okay, so now we want to look at, move that from the studio, the response. So when this motion for limine was filed, then a few days later, the defense filed a response. And I have not read that completely. So we're going to look at that. There we go. All righty. Here we go. How's that? Defendant's response to state's motion in limine and request for hearing. Okay. Comes now the defendant. Oh, Snow's in the house. Snow's in the house. Welcome, welcome. So we're getting into the defendant's response. Comes now the defendant, Richard Allen, by counsel, Bradley A. Rosie, and in response to the state's motion in limine, file marked April 29th, 2024, defendant Allen states as follows, and this is just one day later on the 30th. 1. On April 28, 2024, at 11:15 a.m., the court directed an email, and this, I believe, is the email that we just read previously. to both the state and the defense, addressing various legal and logistical matters associated with the forthcoming jury trial. In the second to last paragraph of the email, the court, without any prompting by lawyers from either side, included the following statement, quote, "I am quite familiar with the law regarding third-party perpetrators, and unless the defense can provide a nexus between any alleged third-party perpetrators in the charged crimes, those allegations are unsupported and will be inadmissible." Did you get your mopo? Yeah, your keyboard. Mofo. 2, on April 29, 2024 at 11:09 a.m. So the next day at lunchtime, the state without hesitation accepted the court's invitation to limit evidence regarding third-party perpetrators. Of course he would. Paragraph 7 of the state's motion in limine is proof of this fact. Oh, I just closed it. What was paragraph 7? Oh, sorry. I'm going to have to open it again. Prosecution answer, defense, prosecution motion in limine. Okay, let me look at it. Seven is the one that says, oh, the one that lists A, B, C, Odinism, cult of ritualism, Bradholder, Patrick, blah, 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 blah. That big long list is number 7. Okay. Number 3, the court has established a pattern of summarily denying pretrial evidentiary motions filed by the defense throughout this case. The motions have been denied despite the defense supporting many of its motions with evidentiary support, proving the nexus in the form of video interviews, audio interviews, crime scene photos, affidavits of witnesses, and various other forms of corroborating documentation. In contrast, the state's motion in limine contains no supporting documents or other information justifying any limitations on the defendant's ability to present evidence regarding third-party perpetrators. Number 4, defendant Allen's defense team is quite familiar with the law. So what did she say? She said, "I am quite familiar with the law regarding third-party perpetrators." Okay. So now they say the defense team is quite familiar with the law regarding the admissibility of evidence of third-party perpetrators, which requires only that defendant Allen establish, quote, "some connection between the third-party perpetrator and the crime," unquote. The court must balance defendant Allen's Sixth Amendment right to present a defense with the state's desire to limit such evidence. Exactly. They're totally, Nick McClellan wants to totally trample on his Sixth Amendment right to have a defense. He's saying, no defense. If it might bring reasonable doubt, you can't say it. Number 5, the defense has spent the better part of a year conducting discovery, seeking out exculpatory evidence from the state, and developing credible defense-related theories, which the defense intends to present to the jury in this case. The state of Indiana has sought out no assistance from the court in an attempt to limit the discovery process. In fact, the defense has conducted numerous depositions involving third-party perpetrators without the state seeking any orders of protection or orders limiting the discovery process. Number 6, the defense anticipates that back up on 5, just so that you guys are clear, that while the state has given them discovery, they've had to go out and do their own interviews. And they basically have had to do their whole own investigation to get first. So it's like with Brad Holder and Patrick Westphal, I don't know if they actually interviewed them, but for example, There is no record. There's only the report of the interview. There's no video, no audio, nothing. So there's no proof of the interview. So they've had to go out and do their own interviews. They've had to do everything over again, right? Number 6, the defense anticipates that its trial presentation will include somewhere between 1 to 2 dozen witnesses, so between 12 and 24 witnesses, that will provide relevant and credible information for the jury regarding the culpability of third-party perpetrators. To the extent the court carries out its warning referenced in the April 28th email that you better have a nexus or it's going to be inadmissible, the trial will be reduced to unnecessary delays due to lengthy offers of proof and lengthy delays due to the large gaps in the scheduling of witnesses, as we had just mentioned, to appear for trial testimony. The absence of any articulated and reasoned legal guidance from the court in advance of the trial would promote the lack of judicial economy throughout the proceedings, right? So it being economical of time, that if the judge has to spend all her time hearing, is this admissible or not admissible, every half hour, every hour, every 15 minutes, then you have to stop the jury and talk about something, and then stop the jury and talk about something, and then stop the jury and talk about something. That is not economical with time. Because if she would have done this before, and hopefully today, right now, they're dealing with some of this stuff, and we'll see what happens. 7, the defense requests the court to set the state's motion in limine for hearing for a full day during the week beginning May 6, 2024, at which time the parties would be entitled to present evidence regarding admissibility of third-party perpetrator evidence. This approach to the business of jurisprudence would assist in clarifying the nature and scope of the evidence to be admitted at trial, which would benefit both parties, the court and the jury. And, by the way, yes, she did. She set it for May 7th, which is today. And number 8, in its motion in limine, the state requested to limit evidence regarding several other matters. The defense's response to each request for limiting instructions is as follows. States paragraph 1. State requests relief from, quote, any comments about counsel for the state that constitutes a personal attack on the attorney for the state, or comments on the role of the state's attorney. Said request is unsupported by any specific facts or allegations, and therefore should be denied. The attorneys, including counsel for the state, are bound by the rules of professional conduct. So basically what they're saying is this is already covered in the ethics, right? So the official rules of professional conduct already have this, right? So you don't need to make a trial judgment about it when it's already a thing, right? And that comes again too. But states paragraph 2, the state seeks to limit the defense from comments which constitute the personal opinion of defense counsel about any evidence, witness, outcome, or penalty. The state provides no specific facts or documentation supporting its request for limiting instruction. The request is unsupported and should be denied. States paragraph 3. The state seeks limitations on the defense as it relates to innuendos or inferences that are not supported by admissible evidence. The request is overly broad, unsupported by factual allegations, and therefore should be denied. States paragraph 4. The state seeks to limit the defense's ability to conduct voir dire through the introduction of substantive issues, in this case, to the jury pool. The state provides no specific references to what substantive issues should be limited. The request is overbroad, unsupported by any facts, and therefore should be denied. Paragraph 5, the state seeks to limit the defense's ability to question potential jurors about their feelings about the credibility of certain anticipated trial witnesses. The state's request contains no specific facts that would support such a concern. The state's request is overly broad and therefore should be denied. State's paragraph 6, the state seeks to limit the defense from introducing hypothetical questions that include facts that are not in evidence or questions that are not helpful in violation of Rule 705. The state's request is overly broad and contains no specific facts or issues for which said anticipated hypothetical questions would be addressed. Therefore, the state's request should be denied. And then paragraph 7 and 8, you see above. Paragraph 9, state seeks to limit the defense's ability to challenge the state's geofencing expert, Kevin Horan, based on relevance. The state's request is overly broad, contains no specific facts which the state is seeking to limit, and usurps the defendant's Sixth Amendment right to present a defense. Therefore, state's request should be denied. Gibbo, hi Gibbo, welcome. Did everyone hear that they pulled the speedy trial and requested Gull removed again? No, I did not hear that. Well, did that just happen in court today? Because they're having their hearing today. And it seems to me in the email that Gull wrote that we just read recently in this broadcast earlier, that she's almost trying to say speedy trial means that the trial has to be fast. And I believe what it means is that the start date of the trial has to be fast, has to be within a certain time limit. Not that it can only be 2 weeks because it has to be fast. Speedy trial is not that the length of the trial is speedy. It's just the start of the trial is speedy. And Queen's in the house. Hey, Maven, sorry I'm late. Was feeding the king breakfast. Oh, well, that's not a bad thing to do. And hugs and hi, everybody. Hi, everybody. And, oh, thanks, Queen, for reminding people to hit the like button. All right. So number 10, paragraph 10. The state seeks to limit the introduction of prior bad acts pursuant to the evidentiary rules. Again, the state provides no specific facts to support its request for limiting instruction. The trial court is granted broad discretion in administering the rules of evidence in a fair and just manner during the course of the trial. The state's request is also overly broad and therefore should be denied. Paragraph 11. The state seeks to limit evidence related to its own failure to provide the defense discovery consistent with a local rule regarding discovery and consistent with Rule 2.5 of the Indiana Rules of Criminal Procedure. That's the labeling one. This is the labeling. However, the state provides no specific facts to support its request for limiting instruction. Therefore, the state's request should be denied. And finally, the last one, paragraph 12, the state seeks to limit the defendant's ability to offer up PowerPoint presentations that were created by the state and its investigative team over the course of their 6-year investigation in this case. The state's motion provides no documentation to support its request for a limiting instruction. Therefore, state's request should be denied. And Michael Westford, Michael in the house. Woohoo! Welcome. Brad Rosie was getting loud with the judge. Trial is now October 14th to November 15th. Wow. So did they break for lunch or something? Yes, they walked in, pulled the speedy trial, verbal altercation with Rosie and Gull, then request she recuse herself as Gull stated they can file that motion. They also brought up a 5th Frank's motion. Oh, I wish they would have had this here, the hearing televised. Wow. Thank you so much for coming into my show. I appreciate it. Of all the shows you came into mine, thank you for updating us on that. So let me finish this last paragraph. Wherefore, Defendant Allen respectfully requests that this court schedule an all-day hearing on the state's motion in limine as relates to a third-party perpetrator evidence. Defendant Allen believes that said hearing is necessary to ensure a fair, efficient, and just determination of the facts to be presented to the jury in this cause. Defendant Defendant Allen requests that said hearing be scheduled during the week beginning May 6, 2024, which she did May 7th today. McClellan said the defense is possession of damning evidence against Richard Allen. McClellan said that the defense has possession of damning evidence that against Richard Allen. And so then they don't want to share it. So let me get rid of that. We're done with that. It's over for today. Hearings expected soon. Oh, wow. So they got it started. They said that they're waiving the speedy so that they set a later date, which means that they have more time to do all these hearings, all these other hearings. Wow. Would either of you like to come up here, Gibbo or Michael, or both of you? You found my channel on the fly. Figure come show my Let me start over. Hey, I found your channel on the fly, so I figured I'd come show some love. You seem level-headed. Thank you so much. I try to be. I do think that the evidence is pointing toward Richard Allen being innocent. But if I'm open to him being guilty, if they show something, if the state could actually show something, but I haven't seen anything yet, so can't go there. But let's see, stop sharing that. Okay, invite, copy. So here, Kathy and Rick's mom was there. Rick didn't even look in their direction. He was so out of it. Wow. Yeah, if one of you wants to come up and actually talk. So did you hear somebody talking about it? Or were you actually there in the courtroom? Both of you. Were you in the courtroom at the hearing? I was actually like keeping defense diaries. No, it doesn't look like Bob Mata came on to do anything. It just has something scheduled. Case closed with CJ. Okay, yeah. Emily Baker's talking about Karen Reed. Truth and transparency. They might sleuth intuition. Just looking at who's on live right now. Not ready to go live just yet. The storm is about to crush Delphi. Oh my gosh, I did see from Montana down to Oklahoma, there was like a cold front, but that might have been like yesterday, so it's probably kept moving over. You're not from here, but I'm here. All righty. Wow. So let me go back and see what you said then. Rosie was getting loud with the judge. The trial is now October 14th to November 15th, so it's a full month. Yes, they walked in, pulled the speedy trial, verbal altercation with Rosie and Gull. Then then requested that she recuse herself, and Gull said, well, you can file that motion. And then they also brought up a fifth Frank's motion. And McClellan said the defense is in possession of damning evidence against Richard Allen. Can you expand on that? You feel bad for the people who booked hotels. Oh my God, yeah, they might not be getting refunds or just partial refunds, right? Wow, and all the restaurants. Can you imagine all the restaurants in the area ordering? You have to order your food in advance, right? You have to stock up. You have to order your stock. And they probably ordered all kinds of stock for their restaurants. And now there's not going to be tons of people, you know. I wonder if they have time to cancel their orders if it hasn't been delivered yet. Hey. What is for Skype?
No. I don't know what I do.
Oh, you want me to ring your phone?
Yeah.
Okay, I got somebody in the house that's like asking for some help. Can't find the phone, so I got to ring the phone. All right. And then just end the call when you find your phone. Okay. There we go. So, okay, that's ringing for them. Rosie told the judge she don't know anything about the case. Oh, she said that to his, Rosie said that to Gull's face. I was just saying that in my live, that she hasn't read anything. Based on her email, when we were going over her email, it's like, well, she would know that if she would have read the nexus, right? The connections, the nexus that she wants, all those connections between the third-party perpetrators and the crime scene are in the Franks motion. So obviously she didn't read the Franks motion. It's probably exactly what he said. Wow. And so what is this, Michael? McClellan said the defense is in possession of damning evidence against Richard Allen. So can you, what, it almost doesn't make sense to me. Why would other than if the defense has damning evidence and they're not wanting to share it, that would make sense, right? Or did you type something wrong or what? Can you clarify? And then Gibbo says, in my opinion, the defense has no case. They are trying to make out they are being mistreated, but it won't wash when the evidence is on the table. Yeah, that could be. I welcome everybody here. Everyone is welcome here. I already said kind of how I lean toward him being innocent, but I'm open to him not being innocent, to him being guilty. I'm open to it. And I want people to be safe and share and with what they, with what you think that's, people getting upset and wanting to cancel people because you don't agree. We can agree to disagree. That was a thing. And when I was growing up, that was a thing. You agree to disagree. You don't get mad and bash people for having a different opinion. And so Michael and Gibbo are saying hi to each other. Excellent. Yeah. Wow. So this is quite interesting. I think it's good. I have to say, I think it's good not to rush the trial in this case. Both sides need to get their ducks in a row. I don't think either Nick or Baldwin and Rosie had all their ducks in a row. I think they kind of know where they want to be, but they don't have the actual evidence ready. I think. I don't know. I get this feeling. Okay. Oh, thank you. Here's the explanation from Michael. He said that they have damning evidence against Richard Allen. That's why they are trying to get everything sealed and tossed. Okay. So Nick said that Baldwin and Rosie have damning, or they know of the damning evidence. And so they're trying to get all of that sealed and tossed. And they've requested sealed hearings. Ooh. Yes. Nick McClellan means they are picking a small point and pushing it as the main point, ignoring the majority, knowing that Nick McClellan won't disclose what they have. Okay. They've filed sealed motions requesting sealed hearings. Yeah, I kind of when I was just going over the motion of limine and the defense's response to the motion in limine, I was kind of there were references to communications. I think it was in Nick's that it was like, well, wait a minute, that must mean that there was some kind of communication that happened, because he was like referencing something that, it's like, well, wait a minute, we don't know about that. And And I agree. And Gibbo says, and I agree, just because we disagree means nothing and starts conversation. Exactly. How can anybody, expand their minds if we don't have conversations? And you know what I find in life? It seems that most of the time when there's two different sides, that both sides are right about parts. We're right about, this side's right about something and this side's also right about something. It doesn't mean it's all wrong. The other side is all wrong and one side's all right. A lot of times it's just, it's pieces, and we come together and, share our thoughts and our thought process and how we came to our conclusion. And then maybe we find, oh, wait a minute, how many of us, it doesn't matter what age you are, can remember a time when you were younger and you believed something different. Something I believed in high school. And it kind of came from, I don't know, maybe elementary school, when we saw a documentary on George Washington Carver and how he did all this stuff with peanuts, right? And they show him pulling up the peanuts out of the ground. Because if anyone doesn't know, peanut is actually a legume, like a bean, right? It's not in the nut family. It's in the bean or legume family, right? But I didn't know that as a peanut. So I thought nuts grew in the ground. And so my senior year in high school, I go back to Georgia, and I'm going to high school in Georgia. And we're on the school bus. And one of the kids says, oh, yeah, I went over to my uncle's house to pick walnuts because his hands were black. Oh, why are your hands all stained? Oh, I went to my uncle's house to pick walnuts out of the tree. And see, they were always teasing me because I was from California. And so my accent, and they're like, oh, say pillow. Oh, listen to her. Pillow. I'm like, yeah. I didn't mind all the joking. And so they start teasing me about because I'm like, walnuts grow in the ground. What are you talking about? Trees? Yeah, right. Okay, yeah, right. And they're teasing me. No, walnuts grow in trees. They do. You pick them out of trees. I'm like, no, you guys are kidding me. And so then I found out that walnuts do grow on trees. I mean, it's the same kind of, we all have an experience or a story where we believed something and then we changed our mind. I found out evidence that walnuts do grow on trees. So Michael says, I built a pool camper for fun to camp out when it's nice. Never thought it would come in handy. I've already gotten texts from people bitching about their reservations. So you were planning to use your camper to go to the trial, and so you didn't make hotel reservations. So they moved the date. It's no skin off your back because you're just not going to go with your trailer or you're with your camper. And but yeah, all these other people, yeah. Oh my God! And like I said, the restaurants, poor restaurants. It's hard to break even with a restaurant, And if you're anticipating all these people having to come and eat and ordering all that extra food, because you got to order sometimes, at least a couple weeks in advance, and we're just 1 week out. So those restaurants have already ordered food. I feel for them. That's hard. I mean, some people if they made their reservation on a credit card, they might be able to do something with their credit card. I don't know. Yeah, it's kind of interesting situation, huh? And all the witnesses and stuff, they were probably all getting geared up. I was mentioning, if they were going to bring the Purdue professor as a witness, then coming in May is like finals in universities. And without having a 3 or 4 day window, he might have to come for the whole 2 weeks and then not even get called because the prosecution would like use up all the time. You're here now. You were staying here in Carroll County because this hearing was in Carroll County, right? Did you have to wait out the storm and then you're driving home? Okay, yeah. Be safe with that. I mean, a camper's not going to do much with the tornado. Make sure you park it someplace, like next to a Walmart or something, You'll be back in October. Oh, excellent. Well, I'm happy to meet you. Do you actually have a channel? Let me see. Let me put can't just copy. So if you have a channel, if you have a channel, write the at whatever, and I'll pull it up and show everybody. But I'd love to have you on as a guest after the trials. Bob Mata's gonna do his own thing, right? And then I don't know, Nick Snay, who knows what? Well, he's banned. He's never going back. I don't care for him so much anyway. He's got plenty of followers. More power to him. He's got people that like him, but I don't know. I don't like his attitude so much. Reminds me of his attitude reminds me of people that I don't like in real life, right? So therefore, it's like heebie-jeebies listening to Rick Snay. The CJ guy seems to be he came out of friggin' nowhere, and he seems to really be trying to talk to both sides and stuff. And then I was just watching Frank Meister to see if they had anything going on. And let's see, All Eyes on Delphi. Is that Rick Snay? And I don't know. I try because I don't want to be in an echo box. You know what I mean? So I try to listen to different people. You don't do the YouTube thing. Okay. But you're getting around. Oh, we appreciate that. We need people who get around. Oh, Chalet had a phone call. Who are we talking about? Oh my gosh, Chalet, did you not hear that the hearing is over and there's all kinds of, as they say now, tea that has been spilled? You got to scroll back in the comments. You heard he's around town. Rick Snay is around town. CJ's around town. Frank Meister, Ruckus. I don't know. I don't keep up with everybody. Who are you talking about that you don't like to watch? Rick Snay, which I think is All Eyes on Delphi. Let me see. All Eyes on Delphi. Let me see. Oh, maybe not. Is that not Rick Snay? Well, the channel has no live videos, and I'm pretty sure Rick Snay has live videos. Oh, okay. Go. Wait. All Eyes on Delphi. I think is this the guy that went out and did got footage? I don't know. I'm looking. I'd have to play one. Oh, Delphi After Dark. Yeah. Okay. You saw Jinx running out of court with her phone. Is she one of those the two girls? I can't remember the name of that channel. So Rick Snay, Delphi After Dark is the one that it's just my personal preference. But even sometimes I'll watch a little bit of what he says. He kind of, oh look, that's Spunky Monkey. If you saw that's Spunky Monkey. I have 8 cats, you guys, that are new. So sometimes you'll see cats wandering around. Small but mighty. Want to spill it for a small YouTuber. I appreciate that. I really do. So screenshot you all. Like, what, you're gonna screenshot me right now in our chat? Oh, Chalet, thank you. Came to a great place. This lady smart. I appreciate that. Oh yeah, Chalet's been with me from the start for sure. We are small but mighty. Later on tonight, when y'all watch lives, you see I was right. Oh, I believe you. That would be really that would suck. To use a Gen X term, that would suck if you're like coming in here and like totally making something up just to like mess with me. But I'm taking you at face value for now, and we'll find out, I guess. Jinx is cool, but her leg ain't hurt. She ran fast as fucks. Oh, is she like a short leg? Is she the one that got in between Rick Snay and that other guy when they were going to have their fight outside? And Snow's just a wallflower. Welcome as a wallflower. We love wallflowers. Yes, you are a pretty wallflower. A very musically talented wallflower as well. Yeah, wow. Oh, screenshot all the comments. Oh, well, I keep them on for YouTube. I keep them the live, the live chat comments will play on the replay. So they'll be there. The comments will be there. Let's see. What is this? 10:30, an hour and a half in. So your mofo will be here on Thursday and just cannot wait. You're itching, itching, itching. For anyone who doesn't know, that's a keyboard. I'm so excited for you. Chalet was asking in the beginning if you'd gotten it yet, if it had arrived. So 2 more days, just 2 more days. It'll be here. That's awesome. So I think this has been a great show, going over what we went over that should have been in the hearing. Michael can verify what you said. Jinx told me the same did Frank. Is Frank the Frank Meister guy? I didn't know, LOL, laughing out loud, but now I do. See what happens when you watch the Maven. Woohoo! That's right. We have fun. And it's not, so I've got true crime nights and I got a playlist for true crime, but then I also got a Gen X night, and sometimes I do like travel vlog stuff. So, if those aren't your thing, just, if you put on the notifications, you see I'm live, and it's obviously true crime, because the thumbnails always got the bloody thumbprint, like their fingerprint, whatever, in the thumbnail of are you ready to ramble? So if you see that bloody print, and then, well, I usually say what case we're talking about as well in the title, then jump in. And if you like, and when we say Gen X, we welcome all. We really do welcome all generations to have fun. A lot of times we do trivia and play games and stuff, and just to like get our brains away from everything else. Yeah, Frank Meister. Oh, in the last 35 minutes. Yeah, because I checked that. I saw that it was live. It came up in my recommendations. And so I clicked on it and I saw that it was Ruckus and somebody else that were there on the show. And so, okay, the last 30 minutes of his live. Yeah, always good, clean fun. Yeah. Jinx is the one that was in the car with Indy. Oh, and Noe was effing with them. Okay. Yeah, I thought that incident, that Jinx was part of that incident in some way. Anyone want more tea? Yeah, I want more tea. Bring it on. Chalet's going to be watching Chad Dayball and your grandson. Hi, Talon. Yeah, bring on the tea. Chalet says it also. I'm more watching the Karen Reed, because I see like so many similarities between it and I mean, as far as procedurally, regarding the Delphi case and the Karen Reed case, they both have a third-party perpetrator theory and stuff. So I like to see how it's being handled. Why is it here like that? Here. Lots of cream, lots of sugar. Ooh, vodka. Yeah, I like vodka. It would go good with my like strawberry kiwi or peach kiwi or peach strawberry. I don't know. It's the powder stuff that you add to water to just add flavor. Sometimes you get them where they're adding vitamins. Diet Coke and the splash of vodka later. There you go. Oh, it's taking a long time for you to write. Yeah, wait, we're waiting. We're waiting for the tea. Yeah, so this is great. I think this is really good for the case. Like I said, both sides need to get their ducks in a row, have everything ready, so that the trial, when it starts, can go smoothly. Okay, so Michael says, someone who I've visited every time I come here to Carroll County, Carroll County, has been your local connect, says Kathy went to Libby's funeral and signed with her maiden name, Walker. And Kathy being Richard Allen's wife. So instead of signing as Kathy Allen, she signed as Kathy Walker. And Snow says she'll get the Celsius drinks. Screenshot that. Okay. Wow. So like she didn't want to be associated with her husband in the book, in the funeral book. Or I don't know. I mean, maybe she just used it. You know, like if I was talking to people that I knew from high school when I had before I was married and I had a maiden name, I might say Miriam Prevost so that they know, because they might not associate my married name with who I am because they would know me from school. I'm just throwing that out there as to why somebody might do that. Around 9 months after Allen's arrest, Libby had a funeral? What? Oh, no. I get it. The contact told you this 9 months after his arrest. That's true. Also, she would have added the last name, I would think. Yeah, that's true. Like Miriam Prevost Arthur. Unless you never did take his name. Yeah. Some people keep their own names. True. So Michael says the rumor has been prevalent lately. As a matter of fact, someone else I talked to tells me the same thing. I think she knew and felt bad. That's one possibility, for sure. You know, so that would be interesting. That would be something for the prosecution to call her as a witness. Oh, but technically, wives don't have to testify against their husbands. They can, but they don't have to. You know, if she knew, she's terrible. Absolutely. If you knew that your husband, or even maybe you didn't know, but you suspected it, and then you went to the funerals. Oh, by the way, that's Cassie. Oh, that's interesting. You know, that's the water bowl. I moved things around. Okay. I decided to rent the room where my office was. So if you if you go back and see my tour of the house from a year ago, or maybe it was 6 months ago when I did the tour. I'm not sure exactly when I did the tour, but, and one of the rooms was my office. Well, I'm turning the office into a rental room. And so this is my big master bedroom of the house is now my like little studio apartment. So you can see I got a refrigerator and a microwave, and right there is the water bowl for the cats. So if I'm going live And the water bowl, there, the water bowl is right there. Then you guys might actually see the cats more often. Chalet says, felt bad. Oh, if she knew, she doesn't know how to feel bad. And Gibbo says she has to have known at some point Richard Allen is the man in the bridge, especially when his statement matched witnesses point to bridge guy activity before the crime. And then Michael says 4 different people told me this. One told me 9 months after his arrest, the other 3 within the past 2 months about the funeral, signing the funeral book. Guilty knowledge. I'm still not buying the whole person didn't take the cell phone away. Yeah, like took it away and then brought it back. How are they going to leave a cell phone behind imposed bodies and all that crap? Sorry, you're talking into your phone. It's okay. Michael says he's incognito, not a creator, but I came on anywhere as quick as I could. No one knows me. I can tell you who all was there today. Was Bob Mata there? I want to know because I haven't heard anything about Bob, if Bob was there. Let's see. That's Piggly Wiggly. If you heard me talking earlier in the show about Piggy. That's Piggy. Yeah, popcorn. You know, the thing that I'm kind of caught up on is it doesn't make I'm having a hard time with the timeline, to be honest. And I think Bridge Guy might be taller than Richard Allen. Richard Allen's pretty short. So I'm not a guy, I'm not one of those like FBI specialist forensic tech people that can do the light and measure the light and the shadow and this and that and everything to know exactly how tall somebody is. But I know there's experts that do that. And I think Bridge Guy is going to end up being taller than Richard Allen. That still doesn't mean that he couldn't be involved, but not as Bridge Guy. I kind of have a problem of any single person committing the crime the way it is, like whoever. I don't think whoever Bridge Guy is, my instinct, my gut is, I don't think Bridge Guy is the guy that killed them. I think Bridge Guy is the guy that kidnapped them. That's myself so far. Until I have something to prove otherwise, I think that Bridge Guy did tell them to go down the hill and did kidnap them. And I really lean towards them being killed in the middle of the night and then, being placed. That's my opinion. Let me go back. You guys are writing a lot here. Becky's sister Brenda was there. Ever see that picture of Kathy Allen hugged up with Brenda? I don't think I have. I haven't seen many pictures of Kathy Allen except for like in court. Bob thinks he's guilty. Bob Mata thinks he's guilty based off the evidence he stated on Gray Hughes. And you talked with him privately on Twitter. Wow. Well, I like the way that Bob is really kind of sticks to just the legal stuff, and like what the motions mean and things. That's why I like to listen to him, because he does try to stay pretty neutral. CFM's, Queen's laughing at Chalet. Michael, David Hennessy was notably absent. Wow. So anyone who doesn't know, Hennessy is the lawyer for Baldwin. So like he didn't need to be there, or he's decided not to represent them anymore because it's like he's getting older and probably hung over at Julie Melvin's. Yeah, Julie, is she one of those 2 girls? Kind of bombshell girls. I say girls, women. Gosh, I can't think of what their show is called. Gibbo. Bridge guy was always 5'5" to 5'8". You can Google that and it states that. So 5'4" is close to 5'5". Yeah. Queen, please don't forget to hit that like, friends. Thank you, Queen, for reminding people. Oh, Richard Allen is 5'5". Let me see his mugshot thing. You're right. It does say 5'5" now. Interesting. Because wasn't he 5'4" before? Yes, I like Bob. He's just trying to show the other side. Sadly, people twist his words. Yeah. But I see him being very neutral, but he does get excited about the defense and their strategy because he is a defense lawyer. But I mean, I think he's pretty fair as far as like not really like if he really thinks that Richard Allen is guilty, that's really interesting. That's really interesting. Julie Melvin is Cody Patty's birth aunt. Oh, she has a channel but deletes her stuff. Okay. Yeah, those I'm it's hard for me to get all the names straight on all the family of Abby and Libby, you know. Oh, Snow's working on a brand new video for your music. It'll appear on the USA official page. Yay, Snow, that's great. You're gonna have to like when it's up, share well, I guess share it with me in Discord because we're on Discord together. And then I don't always check Discord. You might have some messages for. I'll get on after the show. I'll check. I'll check and see. So anyway, I think that we've kind of like ran the course for tonight. And tomorrow is Gen X night, so we won't be talking true crime. But please go watch your favorite Delphi creators just to see who was there sharing their firsthand experiences, and follow the other cases as well. So at the end of every show, one more comment from Gibbo. Bob said, based off the timeline and evidence we know of so far on Gray Hughes, that it doesn't look good for him and he swayed towards guilty. Okay. Yeah. I'm swayed towards innocent, but I'm not going to say 100%. I know there's a lot of people that are, he's innocent, he's guilty. I'm not 100%, but I'll admit I am swayed towards innocent right now. I mean, I think there's something to this Odinist thing. Now, which would then mean, was Richard Allen involved in the Odinist thing? I don't know. Maybe. I want to know why the cult of Odin claimed that kill and why it seems to be staged by people who would have been a part of that cult. Well, oh, Snow, I'm ready to end. Fishy stuff going on. Every time I make a new account with a Philly reference in the name, birdies know it's me and start chirping in my ears because I've been debating this since the first week. Cool. So you live in Indiana, near there. You're not convinced either way, Chalet? What's with the suppression? Did they? So what I'm understanding is that because they jumped in with the speedy trial, waiving the speedy trial and moving the court case to October, that now there's time to reschedule all the other hearings that are needed, such as so they didn't rule on the motion in limine and all the suppressions. They didn't rule on any of that because now they have time to push it out. And they just ended the court here. They ended the hearing. I believe that's what I got out of what Giggo and Michael were saying. Yeah. The whole Odinist thing, Snow, there's a lot of branches of Odinist, different branches. There's different branches, and this one seems to be possibly connected to the group called the Vinlanders. Definitely some of the people that are being presented by the defense as being involved are members of the Vinlanders. And then some of the other people were trying to get into the Vinlanders, and they were probates, meaning they were waiting to be in, they had to prove themselves in order to be initiated. And I wonder, I have no proof otherwise, if Brad Holder didn't think, well, the Vinlanders aren't going to let me in, so I'm going to start my own Odinist group from scratch. And that perhaps, Libby and Abby, for whatever reason, were chosen to be the sacrifices to initiate his own cult. I think that's something that's plausible, but I don't know. Because that would mean that Patrick Westphal was not involved, but that Brad Holder and maybe Elvis were. And I don't know, was Ron Logan complicit with his property? I don't know. I mean, it could be completely wrong. I'm not saying it's right. I'm just saying it's kind of the theory I'm leaning towards. But Patrick Westphal appears to kind of be a bit of a liar, but I don't know if, what he lies about, what's truth. The Vinlanders are extremely wealthy people. They have members all the way up to the Senate. I did not know this. So if that's true, Snow, that would lead toward, if I'm just putting it, if the Vinlanders were involved, then they would have pressure with the police to keep them out, to pin it on somebody else other than them. If you were to go down that road, right? After Gull listed off the court cases she tried, Rosie talked to Alan, and then they motioned for the speedy trial. Oh. Was she trying to prove that she was competent by listing cases that she's tried? Or that she's heard over? She sets the dates the hearing was done. And then Jinx sprinted. And her leg wasn't bad. Gull listed these court cases because Rosie was being smart with her. Man, the two of them head to head. Wow. That would have been something to see for sure. Okay, I got to wrap it up. And I always end with this, that in case you didn't know, love actually can transcend time and space. So wherever and whenever you are watching this, just know that I love you. I do. I appreciate you choosing my channel to spend some time with me. And I look forward to seeing you again. So if you're new, I hope that you like the channel. Not only that, but like the video, but like follow, right? Is it follow? Or is that Facebook? Subscribe. I don't use Facebook that much. So subscribe and turn on the little notification bell, because most of what I do is live. I upload a short here and there, or maybe I'll upload a video about Cambodia. But most of what I do is live. So if you don't have the notification on, you might miss that. Yeah. So, take care, everybody. And yes, I will be here tomorrow, same bat time, same bat channel. Anyone who doesn't know, I live in Cambodia. I'm from California. And so it's 9 a.m. Central Time right now. I mean, so for me, it's coming up on 11 p.m. and we started 2 hours ago. All right. So I always start at my time, 9 p.m. So there you go. So I hope I see everybody tomorrow. Bye.